Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. For more information on any of these stories, you can download our News In document using the icon in the top right of the screen. BEIS has announced that the new Small Business Commissioner, the SBC service, should be available from October. The SBC will handle payment complaints made by UK small businesses, that's businesses with less than 50 employees, against larger businesses. There are some exceptions that they will not consider. For example, they will not become involved with whether a price is fair, but will deal with issues such as whether a large business is attempting to alter payment terms after a contract has been signed. The updated draft regulations are available on the legislation.gov.uk website. The SBC's decisions are not legally binding, but it does have the right to name and shame. The government has announced that it will create a UK data protection law to implement the new standards set by the General Data Protection Regulation, the GDPR. The GDPR is directly applicable EU law, but with Brexit on the horizon, the need for a local law is understandable. The law will also deal with some of the permitted derogations from the GDPR as follows: setting the minimum age to consent to data processing at 13, allowing private businesses to process data about criminal convictions, e.g. as part of an employer's background checks concerning a new employee, allowing automated decisions, e.g. for credit checks, provided there are suitable safeguards in place, replicating the current exemptions for journalistic activity, exempting research organisations from a requirement to respond to subject access requests where this would significantly hamper them from their objectives, and implementing a suitable regime for the processing of personal information for national security or for the prevention, investigation, detection or prosecution of criminal offences for agencies such as the HMRC. The Supreme Court has ruled the Tribunal's fees order of 2013 is unlawful because it impeded access to justice. The order increased fees without a link to the value of the claim. The number of tribunal claims dropped by up to 70% after the order. We wait to see whether the government will attempt to introduce a new fees regime and whether, in the interim, we will see an influx of employment claims. The Court of Appeal in the case of Chesterton Global versus Nur Mohammed confirmed that workers who raise concerns about their employer failing to comply with a legal obligation and who reasonably believe that raising the matter is in the public interest will be protected from suffering any detriment. In this case, Nur Mohammed had raised a concern that bonuses were being manipulated by the company to the detriment of himself and about 100 other managers. The Court of Appeal held that these circumstances were sufficient to meet the public interest requirement. It's worth noting that a claim based on detriment following such a disclosure does not require a minimum employment period before the claim can be brought. In another case, a CEO employed by an oil and gas company raised concerns that proper tendering procedures were not being followed and in breach of corporate governance rules, exposing him and the company to bribery allegations. Two non-executive directors who also had operational duties terminated his employment. The CEO made a claim on the basis that he had been dismissed for making a protected whistleblowing report. The Employment Appeal Tribunal, agreeing with the tribunal, determined that he had been unfairly dismissed for whistleblowing and awarded him over 1.7 million in compensation. In addition, it made the non-executive directors jointly and severally liable for the compensation award. An employment tribunal has held that an employee was fairly dismissed for posting negative comments about her employer in breach of its social media policy. The policy that had been introduced in 2015 stated, amongst other things, that posting comments on social media that could damage the reputation of the employer were prohibited and that serious breaches could lead to dismissal. After the employer had announced that it was planning to move one of its plants, a long-standing employee with a previously unblemished record posted comments on Facebook including that she was the dog's body of the company. The tribunal found that the dismissal, although seemingly harsh, was a reasonable response and therefore fair. The EAT has clarified that regular voluntary overpayments, including standby pay, call-out allowances and associated expenses, form part of normal remuneration and should be included in the calculation of statutory holiday pay. This is the case even where overtime is done in the minority of weeks in the year, for example, every 4 or 5 weeks. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact Radius Law or my colleagues here at LexisNexis. We'll be back in October with more of the month's key legal updates.